technology. Josh is the author of the critically acclaimed Unprecedented, The Constitutional Challenge to Obamacare. Professor Blackman was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Josh has testified before the House Judiciary Committee on the constitutionality of executive actions on immigration. So without further ado, please welcome Professor Josh Blackman.
Thank you. Thank you. It's a pleasure to be back here at UMass. I spoke here last spring, you may recall, on the First Amendment and issues of free speech on campus. Hopefully you learned something from that, because since I've been here, things have gotten pretty lit, shall we say, across the country, but I'm grateful to be back here. My topic today concerns the constitutionality of President Trump's travel ban, which I'm sure you've all read about in the news and then heard about. Before I get to that case, I'd like to discuss another case which you may have studied in constitutional law, and that's the case of Texas versus Johnson. Long before people were taking knees, they were burning flags. And this case considered whether a person could be thrown in jail for burning an American flag. Now, this was actually a 5-4 decision. But to the surprise of many, the deciding vote was cast by none other than Justice Scalia. Justice Scalia cast a tie-breaking vote in favor of the flag burners. Now, Justice Scalia was no fan of flag burners. He once said, now this is the actual quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." Scalia said, "But I am not king." Scalia felt that the answer was compelled by the Constitution and indeed the First Amendment. And I often give this case to my students as an example of where your own political or philosophical beliefs fall and where your view of the Constitution falls. If your understanding of the Constitution overlaps entirely with your own philosophical beliefs, you may want to reassess the former. This is much how I feel about the travel ban. I'm a libertarian. I generally favor open immigration policies. I think the idea of banning the entry of aliens from certain nations merely because those countries have been associated with terrorism is an awful policy. I am also doubtful that this policy will do much to improve our national security. Yet, with my cards on the table, I am convinced that Congress gave the president the power to take the actions that he did. And I'm convinced that the Constitution does not bar him from exercising the powers in the manner in which he did. Now, my talk will be in 5 parts. First, I want to walk into the history of the travel ban, including statements made by then candidate Trump, as well as statements made by now President Trump. Second, I want to discuss the contents of the 3 executive orders, there are 3 now, some of which have been halted by the courts, and who knows, maybe while I'm speaking today, a court will stop the 3rd one. It's entirely possible. Third, I want to discuss whether Congress has afforded the president the authority to take these actions from a separation of powers perspective. Fourth, I will discuss whether these actions conflict with the Establishment Clause of the First Amendment. And last, I want to give you a preview of what I think will happen to this case at the Supreme Court or wherever it winds up. So our starting point, and where this really must begin, is back in December 2015, when few of us, certainly in this room, thought that Donald Trump could ever be president. And then candidate Trump called for, here's a quote, verbatim, "a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on." The verbatim quote. Over the next few months, Trump changed his articulation of that position. He said, "We'll have extreme vetting of people from from certain territories." Now, did he actually abandon his position or not? During an interview on 60 Minutes, he told Leslie Stoll, "Call it whatever you want, but we'll call it territories." Was that a repudiation or a wink and a nod to the alt-right? The following week on Meet the Press, Trump said, "I'm talking territory instead of Muslim." That's not a coherent sentence, but did it amount to repudiation? If any of you have ever read PolitiFact and fact-checking and those sorts of things, trying to pin down exactly what Donald Trump says is virtually impossible. I have an alert on my phone. Every morning it alerts me when he tweets. And I wake up and I'm like, what the hell did he just say? You know, yanking NBC's license. No such license exists, right? So his statements are, in large measure, incoherent. Did he actually repudiate his Muslim ban or not? I'll let you guys think about that for a minute. But fast forward now to the inauguration. President Trump takes the oath of office. Less than a week later, on January 27th of 2017, on Friday afternoon, he issues the first immigration executive order. I'll call this 1.0 to keep them straight. This order unleashed chaos in our airports. For 90 days, certain aliens from 7 countries, Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen. So if you were an alien from one of those countries, you were deemed detrimental to American interests, and you were denied entry. For 120 days, the refugee admission program was suspended. In particular, Syrian refugees would be denied entry indefinitely. So almost immediately after the order was signed, airport officials at these nationwide airports were denying entry from people from these, 7 countries. Did anyone go down to Boston Logan that day? In this room? Yeah, were you there? This was crazy, wasn't it?
Yeah.
Yeah, it was an absolutely poorly executed order. No advance notice was given. So I mean, imagine this. When you got on a plane, your papers were in order, everything was valid. While you were in the air, this order was signed, and by the time you landed, there was now a new policy in place, right? And making it even worse, a lot of the people held at the airports were green card holders, lawful permanent residents, who basically have a vested property right. They have a vested liberty interest in entering the United States. So almost immediately, various judges issued orders, what are called habeas corpus writs, saying that these people must be released from the airport. You may not know this guy probably knows it, but even when you're at the airport, you're not on U.S. soil quite yet. Until you check through the customs, you are not actually on U.S. soil, and the Bill of Rights doesn't apply to you in the same sense it would right here on campus. But that was only the beginning of the lawfare. The state of Washington filed a challenge to this executive order, and a couple days later, a federal judge in Seattle entered a nationwide, and I think it was really a global injunction barring the enforcement of this order. Now, the district judge's opinion didn't really have any analysis. It was like a paragraph. It didn't explain why, but it said, you can't do this. The government appealed that order to the Ninth Circuit. The Ninth Circuit issued a decision a week later, finding that this violates the Due Process Clause. It was sort of a rushed opinion, but they said this is unconstitutional. The government sought en banc review. They didn't get it. There were a couple of dissents from en banc. The government could have sought certiorari from the Supreme Court, but they did not. Instead, what did they do? They said, let's try again. And they announced that on March 6th, the president would issue a second executive order. It's called this 2.0, so we keep track of our policies. And he signed it. What was the biggest change from executive 2.0 from 1.0? So first off, Iraq was off the list. Second, if you were a lawful permanent resident as a green card holder, you were not subject to the policy. Both, I think, were good changes. But they changed the rationale. Rather than quantifying whether aliens from those countries engaged in terrorist attacks, which was, I think, always the wrong question, the new findings instead established that the United States lacks sufficient diplomatic relations with these 6 nations to trust their screening mechanisms. In other words, we don't trust that when we get a Syrian passport, that the person is who the document says he is, right? When we get an Iranian visa, right? Do we trust this person is who they say they actually are? This policy, too, was challenged in court, and federal judges in Maryland and in Hawaii issued nationwide injunctions barring the enforcement of version 2.0. This was appealed up again to the Courts of Appeals. The Fourth Circuit Court of Appeals ruled that these policies violate the Establishment Clause and that they amount to a disfavor or disapproval of Islam. The Ninth Circuit had a slightly different argument. They said that under the statute, the president didn't meet the requisite requirements. He didn't make enough finding to show that people from these countries would be detrimental, that they required a more specific finding of fact. Then things get complicated. The government appealed to the Supreme Court, but they did not file an emergency appeal. Instead, they sought what's called a stay. What's a stay? hey, SCOTUS, please put on hold these lower court rulings. That's what they asked for. Now, the process, I don't want to get into the specifics, but it bounced back and forth between the Ninth Circuit Court of Appeals and the Supreme Court 3 times. On 3 times, the Ninth Circuit gave these unqualified defeats to the Trump administration. And on 3 times, the Supreme Court said, well, we'll give you half what you want, split the baby. You can exclude these people, but not these people. So the Supreme Court already began signaling that the lower courts perhaps went too far in their decisions. But as the saying goes, none of this actually mattered, because Executive Order 2.0 was never meant to be permanent. It had a 90-day clock on it. And eventually we knew that 90-day clock would expire. When did it expire? 2 weeks ago, on September 24th. So breaking news, right? Brand new stuff, you guys. What happened? So on September 24th, the old order expired on its own terms, and the President issued Executive Order 3.0, third one, which was actually called a proclamation. Okay? Now, what is the new basis of the proclamation? This is not a temporary policy. It's a permanent policy. Okay? Oh, quasi-permanent in the sense that it lasts for 180 days, and every basically 6 months the government can revisit it to see if anyone falls off the list. But the basic rub is the countries on this list have demonstrated that they do not share adequate information, and they do not have what's called identity management. That is, when you get a foreign document from, say, Somalia or Iran, the government can't verify that the person is who the document says he is. So the biggest change, Sudan is off the list. Congratulations. Sudan was able to satisfy to the government's requirement that the information was valid. But there were countries now added to the list. North Korea, Venezuela, and Chad. Now, North Korea doesn't really have much significance because, as you probably can imagine, Rocket Man doesn't let many of his people come to the United States. There's not much immigration coming from North Korea. Venezuela, which is again a Latin American nation, not too far from here, the ban only applies to certain diplomatic officials, not the entire country. So the only significant new country is Chad, which is an African nation that's a majority Muslim country. And it's a strange one because Chad actually has a pretty good relation with the US and helps with their counterterrorism efforts. Okay? So these are the 7 nations. So you have Chad, Iran, Libya, North Korea, Syria, Venezuela, Yemen. Those are the 7 nations on the new policy. Almost immediately after this third order was issued, the Supreme Court requested briefing on the question of, is the current case moot, right? Is the challenge of 2.0 moot? And not even 3 days ago, the Supreme Court said, yes, it is moot. They said, vacate the Fourth Circuit decision, go back to the lower courts, start from scratch. So all these old opinions, which I talked about, have been wiped from the face of the earth. They've been salted from the Federal Reporter, right? But that doesn't mean that these cases are over, not even close. This is only the beginning, I think, of what will be the final round of litigation. So now I want to move to my third part and talk about, is this legal? And again, I'll reiterate, I think this is a pretty bad policy, but that doesn't necessarily inform what I think is constitutional. Our starting point, as always, is the statute. We know that the president can only act when he has authority. And where does the president get power from? The Constitution or from an act of Congress? This is black letter law. You'll learn this in common law. I'm not going to discuss whether the president has an Article 2 inherent power to exclude people from the country. I think he probably does, but I don't need to go there because we have a statute. So in the 1950s, Congress enacted a statute, 8 U.S.C. 1182, Section F. And I'll read you part of it. It says, whenever the president finds that the entry of any alien or any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such a period as he shall deem necessary, suspend the entry of all aliens or any class of aliens, as immigrants or non-immigrants. Now, in terms of delegation of authority, that's a lot. When the president determines that a class of aliens will be detrimental to American interests, that's pretty broad, right? It doesn't say determines with clear and convincing evidence or makes specific factual findings. It says determines, finds. There's also no time constraint on it. It says for such period as he shall deem necessary. And there's no qualification. He can simply suspend the entry of such aliens. Now, any of you take an admin law, right? You see these statutes. The federal government shall regulate air so that it shall be clean, right? You've seen these sorts of statutes. What does that mean? Well, generally, if you have a statute that's somewhat vague, you let the agency figure out how to interpret it. If we apply even a modicum of that principle to the statute, the president wins, right? This is a very broad delegation. Maybe it's too broad, right? I think there's an argument this statute violates the non-delegation doctrine. But I'm not troubled by that because I think you do this Article 2 inherent power lurking in the background. I think this statute, to be frank, merely codifies the president's existing power. It doesn't add anything new, it just reaffirms what the president could already do on his own. Now, there's another statute that we have to talk about as well. There are two concepts in immigration law, entry and visas. The mere fact that you have a visa does not guarantee you entry. I'll give you a very easy example. Let's say you show up at Boston Logan Airport and you have a valid visa and you show it to the checkpoint and you have Ebola, right? You have Ebola. Guess what? You're not being admitted to the country, right? The government reserves the right to turn you around if you have some sort of contagious disease. Or let's say another example that's perhaps more common. You have a valid visa and you show up at the airport and you start answering questions to the customs agent and he figures out you're lying. And he says there are inconsistencies in your story. And they figure out that the visa you have was fraudulently obtained. Guess what? You're not coming in. There's a difference between a visa and entry. So there is a policy, it's a statute enacted in 1965 that says the government cannot discriminate on the basis of nationality with respect to the issuance of visas. So the proclamation, the most recent one, does not revoke any visas. It doesn't revoke any visas. The effect is to deny entry. So I don't see these two statutes even being in conflict, but this has been raised in the litigation. But that's not what you're here for. You didn't come here to talk about statutes, right? You want to talk about the Constitution and the Establishment Clause, and that's what we'll spend the remainder of my time discussing. The First Amendment has an Establishment Clause, which says that Congress shall make no law respecting the establishment of religion. Usually this provision comes up in cases involving school prayer, right? A prayer at graduation, maybe the Ten Commandments display in a courthouse, maybe a Christmas display at a county, at a town hall, right? Those are the usual sorts of Establishment Clause cases we hear about. This case is different, right? There's no effort to say that we are establishing Christianity as the predominant religion. The argument's this, that by excluding aliens from predominantly Muslim nations, the president is expressing a disfavor of Islam, right? That the act of favoring some aliens over others is itself sending a signal that the religion of Islam is disfavored. And as a result, it's unconstitutional. So there are a couple, I think, issues with this argument that I want to walk you through one at a time. The first is this. Does the Establishment Clause even apply to our immigration laws? And before you say, of course it does, Josh, does our Constitution apply abroad? Right? Do people outside the United States have constitutional rights? There was a case last week at the Supreme Court, a very tough case where you had a guy on the U.S.-Mexican border who was shot, right? The bullet was fired from the U.S. side, crossed the border, hit someone on the Mexican side. Right, if a police officer in the U.S. shoots someone in the U.S., it's a Fourth Amendment seizure of this person. But what if the bullet crosses the border? Tough case, the Supreme Court didn't exactly decide it. But this is a far more different claim that these rights of religious exercise, these rights of establishment, extend beyond the borders. I submit to you that there's a lot of precedent suggesting that our domestic Establishment Clause case law just doesn't apply overseas, right? We have statutes in the books that give preferences to ministers and preachers for immigration visas. We have regulations in the book that say if you are a priest, nun, monk, brother, sister, right? Basic Catholic clergy, you're given certain priority when you're applying for visas. That sort of thing would never fly domestically. We've had that in the books for half a century. We have statutes in the books that say if you are a Soviet Jew or a Christian evangelical, you get special advanced treatment when you're applying for an asylum, right? If you want to be a refugee and you have this sort of religion, you get special treatment. Maybe those statutes are unconstitutional, I don't know. But I think there's a very good, credible argument that the Establishment Clause just doesn't apply to people outside the United States in this sense. I think it's subject to only rationality review under the Due Process Clause. So I'm going to move on from there. But let's say I'm wrong, right? Let's say the Establishment Clause does apply. What's the argument that this runs afoul of the Establishment Clause? Well, they say the order itself is not everything we have to look at. We also have to look at the circumstances that gave rise to the order, namely President Trump's idiotic statements over the last couple of years, right? And I divide these into two categories, right? You have the statements before the inauguration, you got your statements after the inauguration. Let's take them in turn. I read them to you. Complete total shutdown of Muslim immigration. If you go back even further, he said much worse. He said Islam hates us, right? He opposed the Ground Zero Mosque. He said, I often joke, I think Donald Trump has offended every single demographic conceivable. Women, men, black, white. He basically offends everyone. And he has these awful statements, which I think are repugnant. Can courts consider these statements from before the inauguration, right? Can courts consider these statements from before the inauguration? The short answer is it's never been done before, right? It's never been done before. The courts have looked to pre-inauguration statements to disable the president from acting. And I think there's pretty good reason why. These are statements made when he was simply a candidate, was pandering to crowds, was saying whatever he could to get elected. After the inauguration, an oath is taken, a government is formed, and there's a certain responsibility that attaches. Now, maybe Trump doesn't actually have that responsibility, but I think as a general matter, it would be a mistake to start applying campaign promises to the executive's action. Okay? So that's before the inauguration. After inauguration, I think it's actually a little more complicated. I think statements made once you take the oath of office are fair game. I do. I think in lots of contexts, courts could take notice of statements made after the inauguration. But here, in the immigration context, I think there's this extra caveat. We have a case on the books from the 1970s called Kleindienst versus Mandel. It's a case from the 1970s. And the holding of that case is when judges look at denial of visas, they only look at the reason on the face that was given, whether it was facial, legitimate, and bona fides. They don't study the extrinsic evidence to decide if it was improper. So I think you have some binding case law which suggests you don't go beyond the four corners of the policy. And especially with this third version, this version 3.0, it's facially neutral. It doesn't reference religion in any respect. So if we use this sort of rational basis review for this latest proclamation, it becomes very difficult to strike it down based on some sort of impermissible animus or hatred. And that's not to say that it's not true. It's very likely that this was motivated in part by animus. But with a rational basis review, that doesn't matter. As long as the governor articulates a legitimate reason why this action was done, that settles the matter. And if you read this most recent proclamation, which was almost 20 pages long, it went through on a case-by-case basis. Each country, what sort of information was provided, what sort of information was shared. Somalia has these rules, Iran has these rules for these different categories of visas. It was vetted by the entire apparatus of the US government. To say that this third proclamation is motivated by animus is to basically charge that all these people in the US government are bigots. Not just Trump, but all of them, from the Secretary of State to Homeland Security going on down. I think that's a very tall order. So from version 1.0 to 2.0 to 3.0, this most recent version, I think, has the strongest chance of success. But I don't think that necessarily settles the matter, because the lower courts have still been very eager to, I think, resist President Trump and all his manifests. And some people may absolutely love that. But I want to just pose for a minute the alternative argument. If it's the case that President Trump's campaign statements, which were concerning Muslims, shows he has an animus towards Muslims, does that mean that all of his foreign policy decisions that affect Muslims are now unconstitutional, right? If he decides to start bombing Syria, which I think is what he did, right? Is that an action that can be enjoined by a court because it was motivated not by national security, but by an animus towards Muslims? Give another example. The DACA litigation, about DACA, the Deferred Action Program, the Dreamers, right? A number of state attorneys general, I think including yours, has sued the president, arguing that he can't rescind DACA. And one of the reasons why is because he has animus towards Mexicans and Latinos, right? That he hates Mexicans, and they cite evidence of Build the Wall and Jorge Ramos and MS-13, all those other things he does, right? If it's the case that the president's statements have established some sort of animus towards Mexicans and Latinos, he can't do much with foreign policy. What if he withdraws from NAFTA? They say, you can't withdraw from NAFTA. You're doing this because you hate Mexicans, right? Maybe he say, yeah, that's right, go courts, go. But if you start adding up the pieces, this jurisprudence would basically disable President Trump from being president. Another one. What if he takes action towards women? Maybe he rescinds a Title IX policy, or he defunds Planned Parenthood. And say, Trump hates women. How do we know this? Billy Bush, Access Hollywood, right? Grab him, right? He's friends with Harvey Weinstein, whatever it is. If we start taking, topical humor, right? If we start taking this position that the president's actions should be taken to disable him from making any decisions, this presidency ends fairly quickly. And I simply don't think that that's what the law requires. So I think in the end, ultimately, the Supreme Court will uphold the third iteration of the travel ban. I also think the second one should have been upheld. First one, maybe with some modifications, but for sure the third one will be upheld. I'll pause here and turn to my dear colleague who wants to offer any responses. Then I welcome any of the questions that you may have. So thank you so much. Also, the jury box are very studious.
Well, I just would like to thank Professor Blackman for enlightening us about what's happening with the various iterations of the Trump travel bans, and to thank him and for coming, but also to thank the Federalist Society for not just feeding our minds, but feeding our bodies with Mexican delights. So, I must admit, I'm kind of a softie on immigration. So I'm basically, in favor of immigration. A little bit like the Statue of Liberty. Give me your tired, your poor, your huddled masses yearning to breathe free. And there's a certain sense in which I think immigration has always been kind of the lifeblood of our country. So I guess, I agree with Professor Blackman in terms of my feeling about the policies that are represented by the Trump orders. He has a singularly inartful way of offending people. I mean, to his credit, he can be entertaining and funny, but the downside is I think he actually prefers being nasty, just as a person. And I think this is not a very diplomatic trait. I don't think this is not an aspect of his character that is likely to win friends and influence people, in foreign countries. And like it or not, America is, the leader of the free world, and so in a sense we kind of set the tone, I think, for international relations. And I just think, I just think, the acrimony, both international and domestic, is sufficiently intense, and warfare around the world is sufficiently threatening. And one thinks particularly of the actions and threats really coming from North Korea, but they're not the only ones. So I guess I'm saying I don't. One side of me is not very sympathetic, I guess, to what Trump is doing in this area, right? And I also think the whole Muslim question. I think there is this interesting question about the Establishment Clause. To what extent, by singling out majority Muslim countries for this kind of treatment, whether that in effect is tripping the wire and thus in effect preferring one religion over another in a way that's inappropriate given the Establishment Clause, right? That the federal government should not be playing favorites among religions. Although Professor Blackman raises this interesting point about the application, the extraterritorial application of this, and whether people from abroad actually can assert these rights. My inclination would be to say that I think they probably can actually, because, among other reasons, because these are persons, and at least when it comes to the 14th Amendment, admittedly the 14th Amendment doesn't expressly apply to the federal government, only to state and local governments. You know, it talks about persons not being interfered with in their life, liberty, and property without due process of law, and it's that was, you know, that incorporates the First Amendment as against at least state and local government. So it just seems to me it's, given that that's the case and that applies to persons, I think there is a kind of an argument that, you know, foreigners are persons too, right? They may be aliens and thus non-citizens, but still they have certain rights that are recognized under our Constitution. And I think it would be a mistake to think that the federal government has to give them any less rights than state and local governments are required to through the due process clause. But I do think it's an interesting question that he raises. But I also think it's a much closer question about whether, you know, singling out majority Muslim nations for this kind of suspension of entry, whether that does raise Establishment Clause issues. I think it could, and I just want to leave it at that. I do think there's this interesting issue also about the admissibility of Trump's presidential remarks. Certainly they do shed some light on, you know, what it is that he has been trying to do as president. But you know, in fact, in fact, I think the courts may have been overreaching and striking down the previous immigration orders, right? I think the Supreme Court, U.S. Supreme Court, has rightly kind of scaled back the judicial challenge, and sort of now it's starting all afresh. And I think my sense of it is ultimately that the Supreme Court is probably going to uphold what the president is now attempting to do. But I'm just kind of rambling at this point, but I'm just very appreciative for Professor Blackman for setting a kind of high intellectual level to this discussion. And you know, and the food was pretty good too. So thank you, Federalist Society, and
thank you. We come for the burritos and you stay for the party, right? Thank you. Those are actually very kind words. One of the things I love about the Federalist Society is there are always efforts to try to get professors from different perspectives, and you have these kind, welcoming local professors who, you know, treat these vagabonds from out of town with such kindness. So very warm remarks, and I'm grateful for that, sir. Thank you so much. Now your turn. So questions on your mind. What do you want to know? What can I answer for you? Yes, sir, in the back.
You mentioned Trump's previous words when he was running for president being inadmissible when it comes to proving his point. What about if and when he runs a second time and he's already taken the oath?
Good question. Good question. I think once he takes the oath, everything's fair game, right? In the domestic context, right? I'm an outlier. I think president's statements can be used in the domestic context, but in the foreign policy context, where there's classified information, where there's things we just don't know, rational basis review is all you got, and I don't think you go beyond the four corners of the document. But I think at this point, I mean, he's basically been campaigning his entire presidency at this point, right? Everything he says is fair game. Nothing I say occasion a question. Someone. Yeah, go for it.
So, these sort of orders, could they be overturned on grounds of judicial activism?
Explain a little bit more to me about that.
So the lower courts, like, sort of holdings on just sort of...
Did you just do holdings and scare quotes?
A little bit, because they were rushed. You know, you said it was only a paragraph, and they did this really quick to go after it. Is there sort of grounds here for judicial activism that would make that invalidated?
Well, we usually don't overturn an opinion because there's activists, but I think the problem with these opinions is that they were sincerely held beliefs that Donald Trump is dangerous. There were a lot of reasons why these cases should be dismissed outright. There was a lot of precedent getting in the way, so I'll just run you through some of them. First off, these were facial challenges to an executive order of immigration. I don't think these orders are subject to a facial challenge at all. under a fairly long-standing doctrine, the way you challenge an immigration decision is to apply for a visa and get denied. Is to try to enter the country and be turned away. Then you sue. I don't think any of these orders were subject to a facial challenge, period. Right? That's number one. Number two, in terms of standing, I think in order to have standing, you have to have a case brought by someone with a close family relationship. A lot of these cases were brought on behalf of states who couldn't articulate that sort of interest. Eventually, they were able to get more precise, saying, well, the University of Washington wants to admit a Syrian person who's never been to the United States before, and then, okay, maybe this person exists, okay, then you're standing, right? But I think the courts jumped over standing. Also, I think there's a general presumption that these decisions are not subject to review. It's a consular non-reviewability. Okay, putting that aside. The statute is important. I mentioned this before. The starting point in any separation of powers analysis is the statute. What has Congress said about this? And Congress gave the president a sweeping delegation of authority, one that I think that reaffirms his own inherent powers. If you like Justice Jackson, and you like Youngstown, which I do very much, my jurisprudence is largely grounded in Youngstown here. The scope of judicial review when the president's acting with Congress's back is very small, which I think reaffirms rational basis review. But even if we're not in Youngstown, we have this Kleinen's case from the 1970s, right? The court said you're only looking to the face of the action. Let me give you the facts of the case. I'll explain it. You had a Belgian Marxist, right? A professor in Belgium was a Marxist, and he wanted to visit the U.S. to give lectures on Marxism, right? He applied for a visa. It was denied, right? The AG didn't give him a waiver, so he didn't get a visa. Why was the visa denied? Well, they gave some bogus reason. Well, on your previous trip to the United States, you overstayed and you went to places you weren't supposed to. It was garbage, right? That was not the real reason. So the Marxists challenged the visa, saying, look, the reason why you did this is because you don't like my beliefs, right? And you don't infringe First Amendment rights. Now, it wasn't his First Amendment rights, be careful. It was the rights of Americans to hear him speak. That was actually a constitutional right at issue. They said, our professors in the U.S. can't hear you speak about Marxism. He lost 8-1 to the Supreme Court. Justice Thurgood Marshall wrote a dissent. And the dissent's like, look, you guys, that's not what the real reason is. The real reason is it was a Marxist, right? They said, look behind the curtain. Just peel back a little bit to see what's going on. The Supreme Court said, no, we're not going to do that. We'll look for facial legitimacy and bona fides, right? And the way I read it is, on the face, is it a valid reason? Is it done in good faith? If you go behind the curtain, you look to other things, then you're in Richard Nixon territory. You see, what did Nixon think about this? That's what the court said not to do. So all we have is rational basis review of the four corners of the document. And if we use a rational basis review, this is upheld. The government has given more than enough reasons to survive rational basis review. Especially the third order. The third order gave very specific rationales for why this order has a legitimate basis. Now, it doesn't have to be perfect. I think this order is still stupid. I think it doesn't make a lot of sense, right? There are a lot smarter ways of fighting terrorism. But elections have consequences. So for all those reasons, and also the Establishment Clause doesn't even apply. The courts haven't even bothered to acknowledge that. So there are a lot of reasons why the courts have hesitated before issuing these nationwide injunctions with fairly thrifty reasoning. But they didn't, and I've written about this. I think the judges had sincerely held beliefs that Donald Trump was dangerous, that he was trying to destroy the republic, and that they were there to stop us. Now, I think a quote from Justice Gorsuch, who recently explained, judges wear robes and not capes. They're not here to save us. They can enforce precedent, but they can't disregard it when it serves some other spider sense tingling right concern of what's going on. Now, I think you're right. Actually, the Supreme Court has injected a little bit of, put the brakes on, right? I think the Supreme Court has put the brakes on this a little bit, saying, look, this is not right. They haven't given Trump victories. I'm not saying that, but they basically pulled back, saying, Ninth Circuit, you guys went a little bit too far. Just pull the brakes a little bit, pull the brakes. And even this week, where the Supreme Court issued its order, they could have dismissed the case but left the Ninth Circuit and Fourth Circuit rulings in the books, right? They could have done that. But they didn't. They vacated the Fourth Circuit, saying, we are just wiping this decision off the books. They did not have to do that. In fact, Justice Sotomayor dissented, saying, let's leave that decision in the books. I think it's a good, no, they said, let's wipe it out. Justice Ginsburg didn't join Sotomayor, at least publicly, neither did Kagan or Breyer. So there are a lot of reasons why the judges in this case had, I think it was basically a panic attack, and they freaked out. And the Supreme Court has been somewhat of a voice of reason moderating that. I think it's a very important function that the Supreme Court has played. So whether you can overturn an opinion just because it's activist, I don't even know what that means. But there are a lot of reasons why the court should not have done what they did. Thank you for that. Other questions? Yes?
So if we're just looking at the face of the actual ban, then why would we even concern ourselves with what he says after he takes the oath?
You don't.
Okay.
I mean, that's exactly my point. I think in other contexts where you're not in a rational basis review, you can look at presidential statements. I think that's fair game. But under the Mandel case, this Marxist case from the 70s, you don't, and the statements are irrelevant. Even if you look at the statements after the inauguration, by Trump standards, they're pretty innocuous, right? He doesn't say, I want a muzzle ban, right? He makes all these sort of vague, nebulous statements I think don't really prove anything. You really need the pre-campaign statements to get there. That's why the plaintiffs in litigation make such a big deal. Are you reaching for a hand in the back?
Yeah.
Yes, in the back.
I was thinking, have they ever used the president's words never?
I have not been able to find an opinion. In fact, there are some opinions from the court suggesting that you can't do it. But I have not been able to find any decision. There's some allusions to it. I'll give you an example, right? So you all studied Youngstown, right? This is the still seizure case in common law. You remember that during the Korean War, President Truman ordered the seizure of the steel mills to ensure there was a continuous supply of metal for the war. Remember this case, right? After Truman seized the steel mills, he sent a message to Congress saying, hey, I just did this. If you guys want to pass a statute or something, that'd be nice, but here I am, I'm taking these steel mills. And Congress did nothing. That is the only instance I can find where the court recognized statements made by the president in the separation of powers case. That Truman told the president, told Congress, hey, I just did this, right? I mean, it wasn't like a tweet, right? It wasn't a press release, but it was a communication from the president to Congress. That's one of the only examples I can find, and in that case, the court struck down the president's actions, I think, independent of those statements. I saw a hand somewhere else creeping up. Other questions? Come on. Okay, go for it again.
So, what you are from Mandel? Did you read that?
Yeah.
So, what's the word bona fide mean exactly? Does that mean it has to be bona fide, like under the Constitution, or what does that mean exactly?
Okay, so the standard in Mandel, this is the case involving the Marxists, is facial, legitimate, and bona fide. Justice Blackmun wrote that opinion, no relation, gave no explanation what that meant. He didn't explain the term at all. And as it's developed in 30-something years of case law, it basically means rational basis, right? If on the face of the document there's a valid reason, that's enough. There was another case from 2014 or so called Kerry versus Din. The facts of the case were like this. You had a woman who was a U.S. citizen, and she wanted to sponsor her husband for a visa. Husband lived in Afghanistan. The visa was denied, and the reason given on the denial of the visa was that he had worked for some bank or something that was associated with the Taliban, right? And the husband, or actually the wife, brought the suit on behalf of the husband, saying, no, that's not the real reason it was denied. There's some other reason, right? He wasn't part of the Taliban. And what the Supreme Court said is, look, we're not going to look beyond the rationale given. And even Justice Kennedy said, we just review this for facial legitimacy and bona fides. If the reason given is in good faith that he was associated with the Taliban, that's the end of the matter. He doesn't get additional discovery of the reason why. And I think that's the bottom line. Again, Mandel and Din involved the denial of a visa. I want to make this point very clear. That was a visa denied. Here, there have been no denied visas. It's just a facial challenge to the statute. I'm sorry, to the executive order. So I think it's strictly a rational basis review under the due process clause. I don't think you get anything more than that. Thank you for the question. Other questions? Mr. Federal, yeah, go for it, sir.
So I don't know if we've gotten as far in constitutional law yet, but you compared this to, repealing NAFTA and some of the other policies that might come up that, the court could potentially take away from the executive. But to me, there's some level of, you mentioned rational basis. There's no rationality for this policy that I can see. And yeah, I buy the NAFTA argument that it has been detrimental. I could see a legitimate policy being forwarded by that. Is there any distinction we could make between that?
So are you a 1-0?
2.
2, okay. So in common law, this phrase rational basis review, it's misleading the term. It doesn't mean rational, does it make sense? It means in some alternate universe, could the government make up a reason why this is a good policy? And if the answer is yes, courts uphold it. The rational basis review, as traditionally imposed is extremely deferential. And courts basically don't second guess the government under it. I'll give you, the leading examples of rational basis review is a case called Williamson versus Lee Optical. Remember that case? This involved a statute that said if you were an eye doctor, you were allowed to put lenses into frames. But if you were just an optician, you could not put the lenses into the frames, right? Now, putting the lenses into the frames and measuring them is a task that anyone can do. I'll teach it to you in 5 minutes. Why did this law exist? To put lens crafters out of business, right? To put these small shops out of business that didn't have licensed ophthalmologists on their staff. And the Supreme Court upheld it, saying, look, under rational basis review, if it could possibly make sense in some alternate dimension, right? There's some reason why, right? We can make up a reason. That's enough. The government's gone far beyond that. They've given justification. They go, look, these countries don't have electronic passports, right? Now, I'll level with you. There are other countries which are not on the list that have the same problems. But under rational basis review, in the national security context, that's all you get, right? The answer to these sorts of bad policies is to vote out of office, right? Specifically, if it's in the foreign policy context. If it was domestic, I'd even be more hesitant. But this because it affects people abroad, I think this is why it's problematic. But I agree. It doesn't make sense if you and I are talking about it, right? This is a bogus policy, but that's not what the test requires. Question, Mr. Chapter President. Oh, yes, in the back. Yeah.
Yeah, we haven't gotten too much into the individual rights of the person, the due process clauses yet. But just out of instinct, I feel like under Nixon versus U.S., the president isn't above the law. He isn't above the rights, of the First and 14th Amendment to create laws that might violate those. So, isn't there some...
Can you guys just wait like 30 seconds? We'll finish this question.
Oh, I'm sorry.
So I'm just curious of why, what's the basis of that?
Right, so Nixon v. U.S. is a good case. The president's not above the law. Congress gave him the power to do this. Congress gave him the power to suspend entry indefinitely when he deems detrimental. That is the law. Okay, you guys can go now. Thank you so much. Thank you all so much.